that pressure is off. And if you need my chambers to reach out to Judge Scott's chambers again, based on how things are going, let us know. But we did clear that up yesterday, and Judge Scott was most gracious in accommodating this matter. So with that, is there anything you want to add, Mr. Shepard, to your objections to proceeding in this format that I believe have preserved for Mr. Allen every possible angle that one could take as to why, from your perspective, this isn't the appropriate way to move forward?
Yes, I do.
Okay.
And that is, there is nothing in the law that says the court has to do this event in this format. And there's nothing in the law that says the court is not allowed to have the defendant present if the court so chooses. So it's entirely, within the choice of the court. And the case law that is allowing the court to do this event without my client being present at my table within whispering range of me is, to me, suspect. It's what's called a suspect law that came from a time period when Georgia was under the exclusive control of racists and white supremacists. And I'm going to get to that in a minute. But this case law that is cited by the state's attorney in its brief all emanates from two cases, one in 1968 and one in 1971. And as being alive at that time and aware of what was going on, that was a time period when our governor was a segregationist who was appointed by a segregationist legislature. We had a racist symbol on our flag at the time. So those case law and that entire progeny of cases is suspect as being racist and white supremacist. And these case laws that are cited by the state, if you actually read them, there's no explanation for why my client doesn't have an absolute constitutional right to be here. And for the record, those two cases are Reed, R-E-I-D versus State, 119 GA-APP 368. I apologize, I've been saying 1968. It's actually 1969 is when the appellate issue was issued, but the actual case was earlier. And then Sims versus Smith, 228 GA-136, that's a 1971 case. They don't actually explain why he doesn't have this constitutional right, why my African-American client does not have the right to be present for this, seated at the table and next to me. It just says you don't have this right. And that's problematic because there are many rights that my client has to be present. And this type of decision that just says you don't have the right to be present is emblematic and symbolic of a poll tax or a literacy test or these other Jim Crow laws, where basically the law itself is gender or race neutral, but the application of it is designed to allow poll workers who are racist and white supremacists to only disenfranchise African Americans. And that basically is what this entire progeny of case law says. It says that you don't have this right, but if your lawyer can justify why you need to be present, then you can be present. And that leaves it entirely in the discretion of the judge to say, yes, you have a right to be present, or no, you don't have a right to be present. And that unfettered discretion is the bastion of the racist and the white supremacists. Just like the poll workers in the 1900s and 1800s in Georgia, they would only enforce the Jim Crow poll tax and the Jim Crow literacy test against African Americans. So my client is African American. I need to place that on the record. And he has a right to be present under the Constitution. And there are numerous provisions that provide that right. And the first is the Confrontation Clause, which is in my brief. The second is, as the judge mentioned, his constitutional right to testify under Rock versus Arkansas, 483 U.S. 44, 1987. And it's important to know that there will be findings of fact made during this hearing. For instance, my client is very adamant and vocal that his attorney did not meet with him enough, that she didn't investigate the case, that she didn't do a whole plethora of things, discuss the case that should have been done pre-trial, and there were 2 trials in this case. So he's adamant that he wants to testify and he wants to explain to the court the things that trial counsel failed to do that should have done. And that is, we expect that to be in conflict with the testimony of trial counsel. So there will be issues of fact that will have to be determined based upon my client's testimony and assessment of his credibility versus trial counsel who's going to testify in person at the hearing. So that's Rock versus Arkansas. You also have a constitutional right to effective assistance of counsel on this appeal. And this is a very compelling argument because at the time Sims and Reed were decided, there was no constitutional right to an appointed attorney on an appeal. It did not exist. So you didn't even have a right to an attorney on your appeals. And more importantly, there was no case law that said that you were right to effective assistance of counsel on your appeal in 1968 or 69. It's important to remember Gideon versus Wainwright didn't happen until 1963. So in this time period, this is when we're first beginning to say indigent defendants have a right to counsel. Well, Mr. Allen is indigent, okay? And but for Gideon, he would not even have had a right to an attorney, because Georgia did not recognize that right pre-Gideon. So at the time Reed and Sims are decided, there's no constitutional right to an attorney on an appeal. That does not happen until the year 2005 in Halpert, Halbert versus Michigan, 545 U.S. 605. So since the decision that says he doesn't have a right to be present, that decision is undermined by the fact that now he has a constitutional right to appointed counsel for his first level appeal. We still don't have a constitutional right for secondary appeals, discretionary appeals, or habeas corpus, but we do have that right for this event. But more importantly, there was no guarantee of effective assistance of counsel on the first level appeal until 2019. I apologize, but when I wrote this brief, there was not yet a full cite for that case. It's Garza, Garza versus Idaho, 586 U.S., and I don't have the rest of the cite, although it may have come into play. So this whole decision that he doesn't have a right to be present was made in a vacuum of a right to effective assistance of counsel. So it's important to remember my job is to assist him. And how can I assist somebody who's not in the room with me, someone who's not sitting next to me, with whom I can't communicate in real time by whispering back and forth as things are happening in real time? I have tried in another setting on a bond hearing to do it virtually and having to weigh, do I want to stop everything in order to ask my client this one question? And oftentimes, I don't, because of the flow. It destroys your flow to stop the entire proceeding, get everybody out of the courtroom, go into another room, ask your client one question. He answers the question, and then you resume everything. And then 2 minutes later, oh, you have another question. If my client is sitting next to me, I can whisper back and forth. And the importance of that ability is lost on anyone who has never sat at this table. If you have never been a defense attorney and have never done what I do for a living, you cannot understand the importance of the ability in real time while the thought is in your head to quickly lean over, whisper to your client, he whispers back, and then everything keeps moving. That whole break in the continuity, the whole weighing, do I want to stop everything for this one question? More importantly, things are happening fast. Things happen fast during an evidentiary hearing or a jury trial, and you can't remember everything. So let's say as things are going and it's a 1 hour cross-examination or a 1 hour direct examination, you can't keep track of everything in your head that you want to ask your client and then come back in an hour and expect to remember all the things you wanted to ask. So it's important for me to provide my client with effective assistance of counsel that he be seated at the table with me, able to whisper back and forth in real time. And if you've never done this, you don't understand how it is. It's almost like me criticizing the Atlanta Braves pitcher last night for something he did or didn't do. I don't know. I've never, actually I have pitched in Little League, but never in Major League. And so it's not able for me, or criticizing a coach in a football game. I've never been a coach in a football game. So to understand what they go through, it's impossible. And it's impossible for somebody to understand the importance for me to provide effective assistance of counsel to my client unless my client is sitting next to me. And it's important to note, like I said, that this right to effective assistance of counsel on an appeal and the right to an attorney on an appeal did not exist in 1968 or 1971 when these decisions were first made. In fact, you did not get a right to effective assistance of counsel till 1984, which is after Sims and Reed were decided.
All right. Anything else?
Yes, if I may continue.
May continue a little bit. I want to be clear that the case law I'm relying on postdates almost everything you've talked about. This is an interesting history lesson. And it's part of your argument, which you're entitled to make, all of which I've read about in things you've already filed. So what I was hoping we could do here is have you, if there was something additional that you wanted to include to flesh out the record further. But most of what you've said, I'm remembering from having seen in your pleadings. I don't know that I've ever cited to either of the two cases you're mentioning, but you're certainly free, should the motion for new trial be denied, to bring up to the Supreme Court the exegesis you're doing of these older cases, the cases that my colleagues and I across the state have been relying on to try to move forward with some of these motions for new trial, many of which the defendants are anxious to move forward on. I know Mr. Allen has agreed with you on this. We got that on the record before. Our cases from 2008 and 2010, that's a slightly different time frame in terms of what the flag looks like and who's under the gold dome, et cetera. So if there's a little bit more you want to add, that's great. I'd like for us to turn to the bases for the new trial in short order.
Okay, I'll move quickly then. Okay. The problem with these cases you cite do not provide an independent judicial reason for the ruling. They just cite to precedent. And if you follow it, it keeps going back and back and back. So the 2008 and 2010 cases are not case of first impression or sui judice, and there's no analysis within the case as to why that law exists. It just says this is the law. And they all cite and they keep going back and keep going back and keep going back. And then eventually they get to Reed and Sims and it stops. That's this progeny. So that's like saying that, oh, I've got a new case that cites Duplessis versus Ferguson and it's a new case. No, it's a progeny of Plessy versus Ferguson, which said separate but equal is okay. And then there was 100 new cases between that and 1954 that upheld that racist decision. And so that's what these cases are doing. They are citing to precedent. It's not that this is a new case and we're deciding this new. It's that, oh, we're deciding this because it was previously decided in this case. And that case was previously decided because of that case. And that case was previously decided because of Reed and Sims. So it's all the same law from 1968. There's no new, is this an appropriate law or a good law? And in fact, in the most recent case, the attorney in that conceded that, oh, the law is what is in Reed and Sims. And I'm not doing that. I'm saying that law from Reed and Sims is inappropriate. Therefore, every case that cites to that line of cases is also inappropriate. But more importantly, nobody has actually done an attack on this rule based on effective assistance of counsel. If you read all those cases, find one case where it says that this rule does not violate the defendant's right to effective assistance of counsel, and it doesn't exist. Two, none of these cases look at the equal protection argument that I make. There's not a single case that either the state or the court can cite to where it says this law does not violate his right to effective assistance of counsel, because nobody's made that argument until now. But more importantly, equal protection is a highly important argument because the state, the court, and all these prior cases concede that if Mr. Allen was sentenced to death, he would have an absolute right to be present in this courtroom. Well, my client is sentenced to life without parole, which is functionally equivalent to death. So under the equal protection clause of the state and federal constitutions, you have to do an analysis to explain why Defendant A, who's sentenced to death, has this absolute constitutional right, and Defendant B, who's sentenced to life without parole, does not have this absolute constitutional right. You've got to explain why they are not getting equal protection of the law. The right to effective assistance of counsel, the right to testify, the right to confront witnesses are all fundamental rights. So therefore, under the law of the United States of America, the analysis is strict scrutiny. And you've got to explain why a death penalty defendant gets this right when a life without parole does not. And you have to show that the law is narrowly tailored to achieve a compelling state interest. None of these cases cite what is the compelling state interest in not having my client sit at the table with me. And that is the flaw here. The life without parole is functionally equivalent to a death sentence. The overwhelming vast majority of people who are sentenced to death suffer the exact same fate my client is going to face, in that he's going to die in prison. No chance of parole. So it's a functional equivalent. What is the compelling state interest? And first of all, the COVID's over. We're doing jury trials. We're transporting people. I originally was going to subpoena the head of the DOC, the head of the prison, and Sheriff and Colonel Mark Adger to explain to the court that there is no reason why Mr. Allen cannot be present because of the COVID, that this is just a decision on the part of the court without any basis. Other than that, I just don't think he has a right to be here. What are the compelling interests? Well, first of all, saving a little bit of money where my client's rights are being violated, that's not good enough. There is no compelling state interest for why my client is here, not here today. And that's important, that the court must articulate a compelling state issue and why a death penalty defendant has an absolute constitutional right to be here and my client does not. And we also have to do a new analysis on this law from 1968 in light of the changes in the law, and no court has done that. Read all these decisions. They just say, this is the law. That's it. End of discussion. And it seems like that's what the court's trying to do today, that it's not actually going to go into why is this the law? Is this law a good law? Is this law appropriate? And just citing to precedent and not actually examining why this Jim Crow law exists is exactly what courts did between Plessy versus Ferguson and Brown versus Board of Education. And we had another 50-something years of racist law. And it's time for this racist law to be ended.
All right, a couple things. One, my understanding is that Mr. Allen was not sentenced to life without parole. I'm looking at the final disposition, and he got 2 consecutive life sentences, not life without parole. We need to be careful as we're making a record, as strongly as we may feel about the propriety or impropriety of the notion that someone arguing his motion for new trial doesn't necessarily have a right to be in court with his lawyer, that we not stray too far from the facts. Second, your arguments may ultimately on this issue prove to be most persuasive, but as you've pointed out, these are appellate decisions, and it is not a superior court's role to ignore the precedent. It may be that the higher courts, all the way to our state Supreme Court, need to reevaluate the reasoning behind and the propriety of the cases that stand for the very clear proposition that a defendant does not have an absolute right to be in court with his lawyer for the hearing on the motion for new trial. It is not the role or the position of a lower court to ignore, flout, set aside, or overrule a opinion from a higher court. So I express no perspective other than I appreciate and respect your arguments, and I think you have preserved the record so that should this be a case that goes up on appeal beyond just the motion for new trial, you will be in a position to argue to the Supreme Court that the cases you've cited ought to be changed for the many reasons that you've articulated. And I think you've now made a record through our court reporter that augments the thorough written record you've made through your various pleadings. Ms. Pollock, is there anything you want to say in connection with this preliminary issue?
No, Your Honor, the state will rely on its brief and on this court's discretion to decide the matter. Thank you.
Okay. Well, then I have to fall back on the backup argument that even under this case law with which I disagree, my client has a right to be present if his presence is necessary for the procedure to be fundamentally fair.
Right.
And that's the second half of the argument. I've now argued that that case law is wrong and that he has an absolute constitutional right to be present, and that we don't have to justify why I need him here. But now I need him here for this proceeding to be fundamentally fair, that there are factual issues which this court is going to determine, and that I need him here to be able to testify in the presence of the finder of fact as to those factual issues. For instance, I was not at his trial, And I was not there when any of these issues occurred. And I need his help that as his trial counsel is testifying and saying, okay, this is why I did not object to this. This is why I did not file a motion. This is
give me a for instance, having sat through lots of these hearings, what is a for instance where Mr. Allen is going to whisper into your ear if his trial attorney is on the stand explaining why she didn't object to Alan Smith testify about something Jeremy Andrews said in a trial that was 3.5 years ago. From your experience, what does a client lean over and say, oh, wait a minute, the trial lawyer is mistaken. Here's what really happened. We've got a transcript of the trial, which of course is what we'll control. We have an attorney who will provide some narration and explanation of thought process, assuming she recalls what her thought process was at the time. Of course, you'll be familiar with that as well. Lawyers very understandably will say, I don't remember exactly why it played out that way, but in my experience, I do X or Y or Z. What possibly does Mr. Allen say to you about that situation, that lawyer's experience, the way she practices law, that leads to your next question?
Well, for instance, in this case, there was a juror who had done some external research, and trial counsel didn't move to exclude that research, even though my understanding is these articles this juror read were highly prejudicial to the defendant and basically were saying facts that may not come into evidence. And there hopefully was a conversation about why the defense attorney did what the defense attorney did. That's part of my paragraph 13. And that leads into it is that there was no communication about what the trial attorney was doing or why.
Okay, well, in 13, I think, and I've already flagged this is one where after we've heard from trial counsel and covered some of these other grounds, and maybe heard from Mr. Allen, who is perfectly capable of testifying from where he is, I'll be in a position to assess, you know what, I can rule on some of these, but as for paragraph 13 from both I guess it's 13 in trial 1 and it's 12 in trial 2. It's the same issue that you flag. I'll be in a better position to assess if I, as the fact finder, need to have Mr. Allen sitting right here explaining more clearly his recollection of what he and trial counsel discussed when the issue of the juror purportedly doing outside research came up.
And it also applies to 11 as to why there was no attempt to suppress the search of his cell phone. It's a trial counsel's job to consult with their client and to interact with their client and talk with their client about the things they are doing and also the things they are not doing. So was there a conversation or any input from Mr. Allen about why there was no effort to suppress the cell phone, why there was no effort to suppress the evidence that was recovered from defendant's residence where he has an interest of privacy? Okay. So once again, that all dovetails into 13 about what happened during the representation as to effective assistance of counsel. And that's why I need him here, because I can't say, this is really a catch-22 that I'm put into, because you're expecting me to tell you with concrete sureness that if my client is present, then he will help me and tell me that I need to ask.
I'm not, but you can't do that. And I wouldn't ask you to do that. I'm just asking you to share with me your thoughts about how it might play out. I wouldn't expect you, unless you and Mr. Allen had already mapped out, look, here's the questions I'm going to ask you and here's your answers, but I wouldn't make you divulge that. You've done it. You've explained to me the ways in which Mr. Allen being here could, in theory, support, I think it's paragraph 13. These others, whether or not it was ineffective for trial counsel to fail to seek to suppress the results of the search of your client's cell phone, is an issue I resolve based on the facts about the cell phone, the facts of the trial, and the testimony of the lawyer. I don't need Mr. Allen's testimony on that. Whether she was effective in terms of engaging him and getting his input, that's a separate ground that you've raised. A lot of attorneys fail to pull the two apart, but you've pulled it apart. That's Mr. Allen's testimony. Hey, she didn't ask me about this, and I would have told her X or Y or Z. So we certainly need to cover that. And as I said at the outset of this morning, that may be paragraph 13 from trial 1, paragraph 12 from trial 2, may be where I say, well, we're going to stop here. I've heard argument and evidence on all the court errors. Mr. Allen doesn't need to testify about errors that Judge Downs purportedly made. If you can come up with something you would conceivably ask that's relevant and probative and in any way useful from your client about an error the court made, I guess I need to hear from Mr. Allen on that. That's never happened. Doesn't mean it couldn't, but all those things we can work through. We don't need Mr. Allen sitting by your side. I don't know that we need Mr. Allen logged into the Zoom call if your only allegations were trial court error. That's part of the point of these cases that you're challenging on appeal. That there are plenty of issues that arise in the context of a motion for new trial that they can be briefed. I don't know what evidence one tenders if the argument is that Judge Downs erred by denying a mistrial when Herlicia McCoy said whatever she said. I'll need to see what in the transcript it was Ms. McCoy said. It sounds like trial counsel was on point, made a motion for mistrial, and Judge Downs made her decision. That is, according to you, an erroneous decision, and it was sufficiently prejudicial that Mr. Allen ought to get a new trial. And you may be exactly right, but I could decide that based on your brief, Ms. Pollock's brief, and the transcript. They don't need any testimony on that. So I think we have a mixture of grounds you've raised that we can cover today where you're not going to need to interact with Mr. Allen. If you want to, we've created that opportunity because, of course, he is present. He's not physically present, but he's present. And then second, you've identified some grounds where it may be very appropriate for you to interact with him, and it may even be necessary for him to testify. As we move that direction on the spectrum, your arguments get more and more traction and may convince me at the end of this session that we need a second part of the session. And that session will have Mr. Allen seated next to you. And more importantly, ultimately, Mr. Allen on the witness stand in the same courtroom with you and me. And if the prosecutor wants to be here, the prosecutor can be here. Prosecutor can dial in.
If I could just respond to that as to paragraphs 10, 11, and 12.
Okay.
And that is, it is a catch-22 because I can't say how he would help me with him not here, because then obviously I don't need him here if I know how he's going to help me. It's the catch-22. You can't get out of the war because you say you're crazy, because saying you want out of the war proves you're not crazy. But if you don't ask, we can't let you out. Classic.
So I may have made a wrong assumption, but I assume that you've engaged with Mr. Allen and you already have talked to him about the fact that you think that it was ineffective of his trial attorney to fail to seek to suppress the results of the search of his cell phone. And so he would have been in a position to say, yeah, man. And every time I'd ask her about that, she'd say, I don't want to talk to you about your cell phone. Stop bothering. I'm making it up. But she said something like that. You would be in a position to say, actually, Judge, Mr. Allen has something to say about not the issue of communication with counsel, but specifically the issue of the cell phone. I don't know that he remembers right now that his cell phone had been searched. That may be something that's been dogging him the whole time. Not that he had gunshots through and through that would make it impossible for him to have put his hand in front of his face when he was being shot at. But instead, he's focused on the fact that his cell phone was searched.
Yeah. Okay. And yes, I understand all that. But the thing is, I don't know what counsel is going to say for why she didn't do things. And I've had situations where there was a juror who I'm like, oh my God, how did you let this juror get on the jury?
Yeah.
And trial counsel's response is, well, I talked with my client and he said he didn't want to strike her.
Yep.
And my client is going crazy. What are you talking about? I never said I didn't want the, or counsel says, well, my client told me that wasn't his cell phone, so I didn't think we have standing. And the client's going crazy. What are you talking about? That's my cell. I never told her that.
But that's exactly the example that I think would require us to figure out, is Mr. Allen going to testify from there, or does he need to be here? If what we hear from trial counsel is, and here's my interaction with the client, you are spot on. I don't disagree with you on that. We can't know until we get that testimony. I'm not going to say it again. I think there are a number of grounds that you wouldn't call any witness to testify about. And if we're going to have argument, we should do that today. And Mr. Allen's participation by being able to see and hear that argument is great and sufficient. When we get into your grounds on ineffective assistance of counsel, there's one that clearly implicates your client.
Yeah.
The other three may, depending on what you hear from trial counsel. And if what we hear from her testimony is, well, actually, I talked to him about it, then that's going to be the kind of thing where probably today I'll say, why don't you go talk with Mr. Allen? And if his recollection is different, all the more reason that we're going to need to have part two to this hearing. But I think there's plenty that we can cover now. And it may well be, to another point you've made, that by the time we reconvene, it is the new normal, and that involves the ability to transport folks from Department of Corrections facilities, and there's less of a problem with that. I'd like to dive into the testimony so we can get your witness on her way. And I think you've preserved what you need to preserve. I've made clear on the record several times that you are waiving nothing in connection with your objection to proceeding with this motion for new trial hearing with Mr. Allen appearing remotely as opposed to being seated in person next to you.
I understand. And I just, for the record, they are transporting inmates, because I have had one go to the DOC and come back.
Okay.
So the DOC is, that's why I didn't subpoena the head of the DOC to come testify to that, because I thought that was widely known that the DOC has resumed transporting inmates.
Got it. All right. Do you want to call a witness?
If that's what you want to do.
Well, I open it up to you. I'm familiar with the grounds. I reviewed the pleadings. And so it is now, it's your motion, and we are proceeding over your objection. And so you may want to argue the grounds that don't have to do with ineffective. Typically, we have the witness, the trial lawyer, come testify, and then she's excused, and then we go on to the other grounds. But I don't mean to prescribe the approach you need to take.
We can proceed in that manner where I do my direct examination, and then I will argue grounds 1 through 5 and as many grounds as I can argue. My expectation is my client will testify.
Okay.
My expectation, my client, especially as to paragraph 13 and the second trial 12, is going to be vastly different than the testimony I expect to hear from my witness about their pretrial interactions and discussions.
Got it.
So he is planning to testify today.
Okay.
Okay.
Well, it's good we've got him on.
Today. Not today. His goal is to testify in the presence of the finder of fact. At this time, we call Ms. Zanelli Gubani.
Mr. Allen, it's important that you wave your hands or do something if you are unable to hear what's going on, okay?
All right, I got you.
You state your name for the record.
If you press the little indentation, there you go.
Zanelli Gubani.
Can you spell that?
Oh, I'm sorry. It's Zanele. Last name is Ngubeni.
Good morning.
Good morning.
Hi. Can you tell the court about your educational background?
I have a
Did you
bachelor's.
graduate from undergraduate?
Yes.
Okay, where'd you graduate?
Graduated from undergraduate in 2003. Went to law school at University of Tennessee till 2007. Graduated with a Juris Doctorate degree.
Thank you. Okay, after graduation, did you endeavor to become a member of any organization in the state of Georgia?
Yes.
Join the state.
Yes, I've been licensed in Georgia since 2008.
2008?
I believe, yes.
So that's about 13 years?
Yes.
Can you please tell the court about...
Hold on 1 second. Ms. Rivers, are you able to hear Mr. Shepard?
Yes, if he stands at the podium, that would be great.
I got to be by my transcripts.
So you can be where you want to be as long as you are near a microphone.
Yes, I'm hearing him fine.
Okay, great.
I apologize.
No problem.
Since graduation from law school, can you please let the court know about your work experiences?
All of my work experiences have been in a public defender's office. I started in the Orleans Public Defender's Office in New Orleans, Louisiana, and then I came to the Fulton County Atlanta Judicial Circuit Public Defender's Office in 2009. I stayed until, I think, 2018. I left to go to the Maryland State Public Defender offices in Maryland, and then I returned back to Atlanta in 2000 and I believe 19, the latter part of 2019.
So you were not in Maryland for very long?
No, I was in Maryland for about 1 year.
Okay. And does that mean you could have been anywhere in Maryland, or that's Baltimore?
I worked for the state of Maryland's Public Defender Office, so I primarily worked out of Baltimore and out of Linthicum, but I worked throughout the state.
Wherever the cases were.
Yes and no. So I was the director of diversity and inclusion while I was in Maryland, working with their state public defenders offices. And so I worked wherever there was an office.
Okay.
A public defender's office throughout the state of Maryland.
Okay, and can you please describe to the court what you did when you were at the Fulton County Public Defender's Office?
I was a trial attorney and a public defender.
And as part of that, what type of tasks did you perform?
I represented indigent clients accused of committing felony offenses in Fulton County.
Okay, and during that time period, approximately how many defendants do you think you represented while you were in that capacity at the Fulton County Public Defender's Office?
I have no idea. I'm sure hundreds, potentially thousands over the course of time. I really couldn't give you a number.
Okay. And during this time period, did you act as lead counsel on cases?
Yes.
Okay. And did you act as lead counsel during jury trials?
Yes.
Approximately how many jury trials do you think you did as lead counsel?
I don't know.
More than 10?
Yes.
More than 20?
Possibly. I don't know.
Okay. And at a point in time, were you appointed to represent a Broderick Allen in case number 13SC118880?
Yes.
Okay. And how did you come to be appointed to that case?
He was assigned to me when I was assigned to represent clients before Judge Doris Downs.
Okay.
Were you if I'm using the wrong term, I apologize. Were you the senior PD or the non-senior PD in Judge Downs' courtroom? Or did that distinction not exist?
I was the senior PD in front of Judge Downs. And while I was there, there were actually three of us, but I was the only one handling the murder cases because she had a significant number of murder cases at the time. So those were the only cases that I had while I was with Judge Downs.
Okay. Okay. And so based on that answer, do you remember what the main charge was against Broderick Allen?
Murder.
Murder. Okay. And during this representation, what did you do in order to present a defense for Mr. Allen?
Reviewed the file and all of the reports, spoke with prior counsel. I think I was maybe attorney 4 or 5 on his case from the public defender's office. Spoke with Mr. Allen, interviewed witnesses, talked to his family members, go to just general investigation, go to the crime scene, review the reports, et cetera, et cetera.
Okay. And did you meet with the defendant?
Yes.
Okay. Approximately how many times do you think you met with Mr. Allen?
I don't know how many times we met. We did meet a number of times. He was housed in Alpharetta jail at the time. So we would go up and visit with him sometimes for hours, for however long we needed to be there until until our conversations were concluded, and then we would come back. So it's about an hour 15-minute drive. So that's not a trip that we would rush.
Okay. And at some point, did this case get called in for trial?
Yes.
Okay. And in fact, wasn't this case tried twice?
Yes.
Okay. I've masked myself up. May I approach the witness?
Sure. If they're great, if you could deliver things in one fell swoop, and it looks like you're going to do that. Thank you.
I'm going to first deliver the transcript from trial number 1. And it's a lot. And I apologize. I have tried to put them in order.
Okay.
Based on volume number.
Okay.
Okay, so as I reference you to parts, if there is a situation where you don't have a clear memory of an event, would that help you refresh your recollection?
Yes. I suppose. Yeah.
And just for the record, how long ago was this trial?
November 2017.
So it's been a few years, right?
Yes.
Okay, well, the first issue, and if you want to reference page 3 of the amended motion that I handed you earlier today.
Okay.
Do you recall a time during the trial where you made a motion for mistrial based on some testimony by Miss Herlisha McCoy?
Yes. I will. Yes.
And do you remember the nature of the comments that you found objectionable?
I don't have a specific memory right now.
Can you access, if you want to refresh, would it refresh your recollection to access volume 2, pages 399 to 407? And just read far enough along until your memory is refreshed, then please look up. Okay.
I recall.
Okay. At that point in the trial, are you moving the court for a mistrial?
Yes.
And what was the specific ground for which you wanted to have you felt Mr. Allen was entitled to a mistrial?
I was just moving the screen.
Thank you.
Sure.
The witness had testified about, well, really just because we were unduly prejudiced at that point. I mean, I guess if that's the specific question you're asking.
And what do you recall what the witness had said that resulted in you making a motion for mistrial?
Yes, she had testified that she had a previous conversation with Mr. Allen, and he admitted to killing a lot of people and getting away with it.
Okay, and that testimony, was that testimony about the victim in the instant case, killing a lot of people? Or was that character evidence?
I'm sorry, you said the victim? I don't.
I'm just
Okay.
interrupt for a second. Hold on. I'm trying to figure out, this witness I don't think it's an appropriate question to ask her opinion on what that was. If we're talking about the error you're addressing, it's an error Judge Downs made, not that Ms. Gubaney made. So I'm not quite sure what we're establishing in the record right now. And I don't think it's appropriate for her to opine what was meant by that testimony or this or that. If she had failed to object, let's talk about it. But she did object. She actually asked for a mistrial, and the judge didn't grant it. Now, Ms. Gubaney doesn't need to share with me why she thought the judge did grant it or didn't grant it or whatever. We hadn't gotten there yet, but I'm not following what we're doing here.
There is a rule of law that if trial counsel doesn't object based upon a specific ground, then that ground is waived for appeal. So for instance, there's times when an objection could be based on hearsay, speculation, and lack of foundation. If you only object and say hearsay, and you don't say speculation or lack of foundation, those are deemed waived. So I'm trying to establish exactly what was the basis for her objection. So that way we know what's preserved for appeal and what is not.
Well, then back to my question. The transcript will indicate if Ms. Gubaney said objection hearsay. If all she said was objection, it doesn't matter what her intent was. The record is she said objection. That's a general objection. And to your point, it could be liable to an attack that, what was she preserving there? And her testimony now, I don't think is going to be instructive as to what we're working through. But even more so, I'm not familiar with you raising somewhere in your grounds that Ms. Gubaney mishandled the McCoy testimony.
I'm not. I'm just trying to establish a record today as to the exact nature of her trial objection. And as a defense attorney, not with Your Honor, but with other judges, they don't really let you get your objection on the record. They cut you off, tell you to sit down and shut up, and you can't fully explain at the time of the trial what was the basis of why did you say objection, and then the judge cuts you off and you don't get to say hearsay, speculation. So I'm trying to get her to say, what was the nature of this objection? Is it because she felt it was character evidence, or what was it? To make sure that I have a record as to what her purpose and intent was at the time when she said objection, move for mistrial. But I will move on. It's just one more question is, what was the reason why you felt, what was the legal reason why you felt the evidence was objectionable? That's all I need her to say. What was why did you think that a testimony was grounds for a mistrial?
It was improper character evidence.
Thank you. Okay. At any time, and what happened? Did the judge rule against you or in favor of you?
She overruled the objection.
Okay. At any time, did you waive your objection?
I don't believe so.
At any time, did you acquiesce in the court's rule?
I don't believe so.
Okay. Going to paragraph 7. You remember a time when there was testimony by state's witness Alan Smith, where involving, if you want to change to volume 3, pages 609 to 614, do you remember making an objection to testimony by Alan Smith?
Yes.
Okay. And did you object to that testimony on the part of Alan Smith? 609 to 614 in volume 3.
Yes.
Okay. And what was the nature of the testimony on the part of Alan Smith that you found objectionable?
My objection at the time was that it was an improper reflection of Mrs. Smith's recollection.
Okay. And did you feel that that testimony was improperly bolstering the testimony of witness Jeremy Andrews?
Yes.
And that was the ground for the objection?
Yes, there were two objections. One was improper reflection. The other was improper impeachment. And that was the bolstering objection that I was making.
Okay. And did the court rule for or against you?
Against. She overruled the objection.
And at any point, did you waive that objection?
I don't believe I did.
At any point, did you acquiesce in the court's ruling?
I don't believe so.
Okay.
But I mean, I'll defer to the transcripts, but I don't believe so.
Turning to paragraph 8. Of the motion. At some point in the trial, did you make a motion for a directed verdict?
Yes.
Okay. And was that motion granted or denied?
Denied.
At any point, did you waive that motion for directed verdict?
I don't believe so.
Did you acquiesce in the court's denial?
I don't believe so.
Turning to paragraph 9.
Okay.
Do you remember during the trial, towards the very end, it came to light that one of the jurors was engaging in deals with the victim?
I do remember this conversation. I don't remember exactly at what point it came up during the trial. Or if it came up before. I don't remember exactly at what point this came up. That's the short answer.
Would it refresh your recollection to look at volume 6, pages 1044 to 1051?
Okay.
And so we're clear, your allegation is not that the juror did deals with the victim, it's that the juror's ex-boyfriend did deals with the victim. I need you to be clear with, you may have been unintentional, but you shifted your argument.
I apologize. It was the juror's ex-boyfriend. I
Okay.
apologize.
That doesn't weaken your argument. I mean, there's an issue here that needs to be worked through, and I hope Judge Downs thoughtfully did so, which she usually does.
Yeah, and I apologize. I've completely overlooked that he was sentenced to 2 consecutive life sentences. I apologize. And as a trial counsel who does hundreds of these, it's just they start blending. I apologize.
Yes, I remember this.
Okay. So at what time in the trial did this occur?
During deliberations,
Okay. And how did it come to light? Do you remember?
the juror sent a note out.
Okay.
The jury sent a note to the judge.
Okay. And what was your response?
Talk to Mr. Allen and then discuss what the issue was, determine whether or not we wanted to move for him, the juror to be removed or not. And then our response to the court was that we didn't have an objection to the person remaining on the jury. The judge subsequently brought the person out and questioned that person about the nature of the relationship between her ex and Mr. Allen. Quite candidly, they had what seemed to be a positive relationship. And so they didn't have any problems with one another. And we did not object to that juror remaining. And then they proceeded with deliberations.
And this would be the jury that actually hung on all the serious counts.
Yes, this was the first trial.
Okay.
Okay. Thank you. Okay, moving to paragraph 10. And you can see this in volume 1, pages 243. Wait a minute. Wait, maybe it's hold on one sec. I think it's
Mr.
volume 2.
Daney, oh, I'm sorry. We're still on trial 1. You're right. Never mind.
Try volume 2, pages 234 to 325. I think that's actually where the issue is. The volume 1 pages, Your Honor, are more that person's initial voir dire that resulted in him getting on the jury.
Your cite to the record, though, for volume 2 is 90 pages long. I don't want Ms. Gubani to read 90 pages.
And I only have one copy of the transcript.
Maybe it's 324 to 325. That's just one transposition of digits. So why don't you look at volume 2, page 324?
That makes sense.
Is that where it starts with the issue with juror 3? It's conveniently highlighted.
Is it?
Yeah.
Okay.
Okay, here you go.
Yeah, transposition of digits.
Okay.
Okay, and so what had that juror done, number 3?
Reviewed, it looks like they reviewed an article on ajc.com and an article from 11 Alive through a Google search.
Okay. And did you move to have that juror removed?
No.
And what was the basis for that decision?
Well, we reviewed the articles, we shared them as a practical matter, any decision that I would make, I would talk to him first. So
Him being your client.
him being Mr. Allen. So we would have shared with him the articles because there were some court exhibits, make sure he saw them as well, talked about whether or not we wanted to keep the jury as it was or make a request to make some argument before the court to change the jury. And so we ultimately decided to move forward with the jury as it was based on the review of the articles. I don't have the articles in front of me, but I absolutely would have looked at them at the time and also allowed him and whoever my co-counsel was to review them as well.
Okay. So did Mr. Allen have input into that decision?
Absolutely.
And what was the nature of his input?
It's not in the record, but I can say if Mr. Allen had an objection to the juror remaining, we absolutely would have raised that objection.
Okay. So your trial decision was based in part on communications with Mr. Allen?
Yes.
Okay. All right. Moving on to paragraph 11. Do you recall that there was evidence introduced into trial that was recovered from a search of the defendant's cellular telephone?
Yes.
And did you object or file a pretrial motion to try to suppress the evidence of the search from defendant's cellular telephone?
No, I don't believe I did.
Okay. Did you consult with Mr. Allen about that decision?
Yes. We talked to Mr. Allen about, quite frankly, whatever we did in the case, we would have had a conversation about it. So we talked about the case, the evidence that they had, the motions that we did file, the motions that, we didn't file, what we felt like were the issues in the case for the trial and for the defense, and what we felt like were not issues in the case as far as for the trial and for the defense. So we would have had conversations about the defense process.
Okay. And so state's exhibit number 5 was admitted into evidence without objection. That's the results of the cellular telephone dump.
Yes.
Okay. And there was no pretrial motion to suppress that.
No.
And was that a mistake or a trial strategy?
That it would have been a trial strategy. We had certain issues in the trial. That was not one of them. We had certain defense issues, and that wasn't one of them.
Okay. And what was the reason for the decision not to object or to try to file a pre-motion to suppress? Why did you decide not to go down that path?
there were certain statements that were made by Mr. Allen to law enforcement
Okay.
that they responded to.
Okay.
And so part of our strategy was to try and narrow the focus for the jury on what we thought was an issue. The cellular records were the cell records, and quite frankly, the search of the house were part of their response to his statements. And that wasn't what we were taking issue with in the trial. Our issues in trial were their lack of investigation and following up on his statements, not as much the statements themselves, if I remember correctly.
Okay. So you kind of moved into paragraph 12 there. In this case, was there also a search of defendant's residence?
Yes.
And was there exhibits 257, 258, and 259 that were admitted into evidence?
Yes.
Okay. And this search, was it performed pursuant to a search warrant?
So I think the record would have to speak for this, but I feel like I recall there being a search warrant for the home, but I'm not, I won't speak.
Okay.
I don't know. I would have to defer to whatever the record shows.
Okay. We should look at volume 4, pages 800 to 801.
Okay. Okay.
Is that where this evidence is being admitted?
It appears so, yes.
Okay. And if you look at 795 to 796, which is right there also, and is that where the evidence of the cell phone is being discussed?
I'm sorry, what were the other pages?
795 to 796 is right next to it.
9-5. Yes.
Okay. So as with the evidence from the search of the house, was that something you did not oppose or object or file a pretrial motion to suppress?
I don't believe I did, no.
Okay. And was there a discussion with Mr. Allen about why that evidence was allowed to come in unopposed?
Yes, we would have talked about those things. Also, there were some aspects of those pieces, those documents that we're talking about now and the evidence that came in.
When you say documents, meaning things found in Mr. Allen's residence? I don't know what was tendered.
Yeah, things found in his residence, as well as the phone calls that we wanted to argue to support portions of our defense.
Okay. So based on that answer, this was a trial strategy not to seek to suppress this evidence?
Yes, because there were some aspects of his statements that we needed some degree of corroboration for, and we were able to get them or explain from some of the evidence that came from the house or from his cell phone.
And what you just said was the nature of the basis for your trial strategy?
Yes.
Okay. Moving on to paragraph 13. If you want to look at this, there's a number of subgrounds within this case. Approximately how many times did you discuss defendant's case with defendant prior to the commencement of the trial?
The short answer is I don't know how many times I met with him. My communications with Mr. Allen especially were different in the sense that, okay, when I got the case, there was a pending evaluation that had to be finalized, and we had retained someone privately to do that evaluation. And so our first interactions, my first few meetings with him involved that evaluator. And that's how we kind of met and started to talk. For a number of times that I would go and meet with him, he just would not talk, which was, that is unique. I typically have more robust conversations with a client who is as close to trial as he was. His case was significant. It was several years old at the time I had it.
When you say that he wouldn't talk with you, he would talk with you about other things, the weather or how his arm feels, or you would ask a question, how you doing? And he would no words would come out of his mouth.
He would not talk. There were no words. He would literally sometimes we would just sit there for hours.
Just looking at each other.
Yes. Or I would be talking, I would talk to him, but he would not respond. And so that went on for a while. And I want to be clear, right? We didn't have a hostile and antagonistic relationship. He just was not communicating. He wasn't communicative. So that went on for a while. At one point, we raised this issue with the judge because it was, being specially set for trial. And we asked the judge to bring him in to court so that we could talk about the fact that he wasn't talking. And so we had an ex parte hearing, and, the judge made it clear that the case was going to go to trial. We needed to talk, et cetera, et cetera. After that ex parte hearing, I saw him several more times, and he started to talk a little bit more. Actually, he started to talk a little bit more after he found out that I was talking to his family. I had a number of conversations with his mother and other, maybe like one or two other people in his life. And then I asked her to ask him to talk to us. And then he started to talk more, and he started to open up, and then we started to have more robust conversations as the trial was moving up. So after the judge had the ex parte about the court date that was coming up, and I think he started to feel more comfortable after he knew that I was at least reaching out to talk to his family, or I would tell him who I talked to, right? If I went to this crime scene or talked to that witness or whatever, I would tell him what we'd done. And then he started talking a little bit more. So quite frankly, by the time we got to trial, I didn't have any concerns about his ability to communicate with me. We started trial in a very good posture as far as I was aware. We ended trial in a very good posture as far as I was aware.
Was it your sense, you say his ability to communicate, was it your sense that it was ability or willingness, that it was a voluntary decision? I'll listen to you. You can talk about the case. We're not going to file this. We are going to do this. But he was choosing not to respond to your questions, as opposed to there was some medication that was making him incapable of responding to you.
It was absolutely willingness. That was why we had a psychiatrist involved, because I needed to confirm whether it was an ability or a willingness first.
Okay.
And that was my first issue. And so that's why she came out a couple of times. We even talked to the deputies at Alpharetta jail to find out if there was something that we were missing. And they would relay that he talks to him just fine.
So it's not as you said, an ability to communicate, but what you meant by that was his willingness. You invested in the relationship. Judge Downs weighed in. Family members were saying, look, Ms. Gubini's good people, whatever the words were. And so before trial, you reached the point where actually Mr. Allen would engage with you on whatever the topic was.
Yes.
Okay.
We did. And even during the course of trial, he would write questions for witnesses. He would give us information, feedback. We didn't have any communication issues that I can recall in the first or the second trial.
Okay. So during these discussions, were you able to discuss the evidence against Mr. Allen with Mr. Allen?
I did. So I mentioned I was maybe attorney 4 or 5 on his case from the public defender's office. So I know it was a situation where almost every time somebody started new, I think he was getting the same information and reports again. I know when I first met him, that's where I started. Also because once I was representing him, and we had a specially set trial date, there was new evidence that was coming up, new reports, there was a new forensic reports, a number of things. And so I would always just make sure we were on the same page, and I would give him a copy of whatever I had. And it was, in this case, it was, the discovery was voluminous.
Yes, I know. I have your file.
So, I mean, we did talk about the information in the case.
Okay. At any point, did y'all discuss any witnesses that the defendant wanted to have testify on his behalf at his trial?
Certainly did. I mean, I would not have filed it. If there was a witness that he had asked me to talk to, or even go see or visit or ride by, I would have at least followed up. And then if there was somebody that we were going to call in trial, I would have subpoenaed them.
Hey, do you remember calling any witnesses?
I cannot recall specifically right now.
Okay.
Yes or no. I'm sure we filed a witness list, and I would have to look at
Would
that.
you refresh your recollection to look at the table of contents that lists the witnesses? It will be towards the back of the where the state rests. So I'm guessing if you started somewhere in volume 5, you might see where the state rests. And if you called any witnesses, just the table of contents in the front. I think there are table of contents for this trial transcript. Masked up and approach.
Volume 5.
Okay. Well, if we just rested, then it'll say we rested after the. It looks like we did 8:45. Maybe we didn't.
Okay, so based upon that.
No, we did not.
Okay, so based upon your review. Based upon your review of the table of contents, you did not call any witnesses for the defense?
No, we did not.
Did Mr. Allen testify?
Oh, no, he did not.
And did you in any time discuss with Mr. Allen the ramifications of a decision by him to testify or not testify?
Oh, absolutely. Yes.
Okay.
There was a long statement in this case.
Okay. And was it did he want to testify or not testify?
Mr. Allen did not want to testify. I don't recall ever having a conversation with him about his desire to testify.
Okay.
I shouldn't say that. I don't recall him ever indicating in any form or fashion that he wanted to testify. And we talked about it because he gave a statement to law enforcement in this case, and there were some parts of that statement that we just were not going to be able to address or provide context to for the jury. And we had to have a conversation about what that meant and what his testifying, what else his testifying may or may not include questions about.
Okay.
He was the only other, the incident involved 3 people. He was the only one of the 3 people who was able to talk about what happened in that moment. So we had to have a conversation about that.
Okay. All right. I think that concludes. Let me check to make sure. That concludes my questions for trial number 1. Do you want me to move on to trial number 2?
I do. I know Ms. Pollock is being very patient, but I will note that a number of the grounds for trial 2 overlap. So in particular on the ineffective. So I don't know that you're going to need to re-question Ms. Gubani, but you'll do what you will. That similarly in trial 2, Ms. Gubani did not seek to suppress the results of the search of the defendant's cell phone. So I'd like you to push through trial 2 as well, and then we'll see if there's any cross-examination.
Okay, masking up, may I retrieve those transcripts and bring you a whole new set?
Okay.
Please, Ms. Gubani, you need a break or are you good?
No, I'm good. No, I'm fine. Thank you.
Okay.
Thank you so much. Be right back. I just didn't want to get them all intermixed since they're separate trials. So here comes number 2. Okay. Somebody needs to invent reading glasses that don't steam up when you're wearing a mask. You're too young to know what we need reading glasses for.
That's what you think, but I'll take it as long as you can. As long as I can, rather.
Yeah, reading glasses. Okay. Okay. So just briefly, let the court know why they needed a second trial. This case needed a second trial.
The first trial hung. There was a hung verdict from the
On
jury.
everything? Or were there some guilty verdicts and some not guilty verdicts?
I can cut to the chase
I believe
and
it
take
was-
judicial notice that he was convicted of aggravated assaults and some gun charges. So there was a verdict and a sentence from trial 1.
Okay. And then not guilty on all the murder charges, correct?
Not guilty, hung.
Hung. I mean, I apologize. Hung.
Correct.
Okay. So the state decided to go forward with a second trial.
Yes.
Was there any efforts in between the first and the second trial just to try to see if you could take a plea to something less than murder?
Yes, we had conversations, but not very much. I mean, quite frankly, the state was pretty adamant about moving forward on the murder charges. So, we talked about it briefly to see if they would be interested in resolving the case. I talked to Mr. Allen about it. State definitely wanted to move forward, and quite frankly, Mr. Allen wanted to move forward, if I recall that correctly, too.
Okay.
Do you recall anything about the hung jury? Did Judge Downs end up ultimately disclosing it was 11-1 to acquit, or it was 6-6, or anything? Sometimes the lawyers like to learn, well, was it close? Do we incentive to work it out? If it was 11-1 to acquit, the state's going to have a very different perspective than if it was the other way around.
There was some more information we had. I believe it was either 10-2 or 11-1 to convict. And I don't remember the exact split. I know that there was a split, and I believe it was either 10-2 or 11-1. It was a memorable deliberation because there were some, incidents that occurred.
Okay, thank you.
So ultimately, was the decision that was given to Mr. Allen for the first and the second trial either plead to the indictment or go to trial?
Oh yes, yes. We didn't. I don't recall having a formal plea offer of anything less than life or the indictment.
Okay. How long had you been in Judge Downs's courtroom at this time?
Oh, I don't know.
Had you seen her sentence on cases before?
Yes.
Okay. And did you discuss with Mr. Allen the possibility that she would probably just give him one life? Did you discuss with him the chances that she would go consecutive and give him multiple lives in multiple years, or what your estimation of what she would do on a non-negotiated?
So absolutely talked about the the potentials of a trial, right? And whatever the maximums were on a trial. In this case, there were consecutive life sentences involved. We also talked about the possibility of entering a plea and potentially asking her to go, to do just a singular life offense. If I remember correctly, Mr. Allen was not interested in a plea offer, and the state was not interested in making one. So this was a case that, quite frankly, from the time we picked it up, we knew would be a trial at some point. And I know that other counsel, because I'd spoken with them, had also had conversations about resolving the case. I think by the time I had it, it was maybe 5 years old or something. And this was not a case where there's any meaningful or substantive negotiations happening about anything less than a trial.
Okay. All right, moving on to trial number 2. If you reference on the motion that I handed to you earlier, paragraph number 6. And I assume you conducted voir dire?
I know that I had co-counsel for both trials, and I can tell you that, quite frankly, with both of them, we would often alternate jury panels. So either I did or my co-counsel did.
Okay.
I think the bulk of the trial I handled, but for voir dire, we would often rotate panels.
Do you remember asking the court to replace the entire jury panel?
I do.
Okay, if it would refresh your recollection to first look at volume 1, pages 180 to 187. And once you've refreshed your recollection, look up.
I recall.
Okay, I'm going to ask you just briefly skim. Okay, let me restart. So basically, were you asking for a new panel because jurors 2, 5, and 7 had made comments during voir dire that might prejudice the remaining jurors?
Yes, about gang involvement.
Okay. If you could briefly skim juror number 2, which is pages 54 to 61, 54 to 61, just briefly skim what juror number 2 was saying. And then let me know when you're done with that.
Okay.
And now if you could briefly skim juror number 5, pages 72 to 79. And let me know when you're ready.
Okay. Yes, I'm ready.
And then finally, juror number 7, that's 79 to 84.
Yeah, I remember that. Okay.
Okay, and so what was the basis for your request to replace the entire jury panel?
all of these jurors had very strong reactions to hearing that this was a case that might have involved gangs. And they talked about their personal experiences with gangs and why they, were predisposed not to be impartial in a case involving gangs. And those conversations were in the panel in open court, as I can recall it. And then there were a couple of times during the course of that questioning where the court's response was an attempt to correct, I guess, or to address that atmosphere. And I think she made a couple of statements about just, we don't like gangs, that kind of thing, to try and, lower the level of, I think, concern that people have started to create around gangs. And so that ultimately was why we had asked for that whole panel to be removed, because at that point, we had a real concern about people's ability to continue to listen to the case, listen to the evidence in the case, in light of the fact that there may or may not have been gang involvement in this case.
Okay. And did the court replace the panel?
No,
Did you ever waive your motion to replace the panel?
I don't believe I did. No,
Did you ever acquiesce in the court's ruling?
I don't believe I did.
All right, moving on.
When we're saying panel, so I'm clear, is that all 60 people or whatever the number was? Or was it a group of 12 because it came up when you were doing individualized? So it wouldn't have been replacing everyone, just a piece.
So based on, I guess, like knowing myself, right? And I can't say right now specifically exactly what I said to her. I can say that I believe my concern would have been about the entire panel and not just the group that was in front of us, because people were coming and going.
Okay.
And they had the ability to talk and interact. And this was a multiple day voir dire situation.
There wouldn't be a way to isolate it to these are the 12 that might have been improperly affected by whatever the exchange was.
That is correct.
Okay. Thank you.
Okay. Moving on to paragraph 7. Do you remember making a motion for new mistrial based upon something the state's attorney had said during the trial?
Yes.
Okay. And would it refresh your recollection to look at volume 2, pages 407 to 413?
Yes, I remember this.
Okay. And could you provide the court with the context for your objection and motion for mistrial?
So this was a hot button issue. So we retried this case shortly after the first trial. At the time the second trial was had, we had not had access to the trial transcripts from the first trial. There was a witness, and I believe this might have been Alan Smith, but I didn't even look to see who was testifying. But at the time, there were a couple of statements that came up in the first trial that were not part of the pretrial record, right? So there were omissions and impeachment issues that came up during the first trial. And our only record of the witnesses' responses were in the trial transcript from the first trial. So before the second trial, we actually had made a pretty strong request to continue the case until we had access to the trial transcripts for the second trial, because we knew that there were things that, came up in the first trial that we had no other source of information for. So during the second trial, there were attempts made to impeach witnesses based on statements that they had made in the first trial and had changed in the second trial. And, you know, I don't feel like we were as successful as we could have been had we had access to the first trial transcripts. But what I specifically made a motion for mistrial about in this instance was that the state was fully aware of that issue, and rather than leaving whatever the impeachment, wherever it fell, leaving it where it was, she made a suggestion that we made some things up and didn't have a basis for the questions in that second trial. And I thought that was improper because she was present for the first trial. She was fully aware that we didn't have the trial transcripts. And I thought that was going too far, quite frankly. So that was the basis of the mistrial in that instance.
Okay. And what specifically was the statement that trial counsel for the state made that you felt was inappropriate and prejudicial? It's probably on 407.
In her re-questioning of the witness, the prosecutor asked the question to the witness, and you have no idea if the defense attorney, when she said you said this previously, whether you actually said that or not, do you? The witness said no, and then she said she could be making it up. And the witness said yes.
Okay, and what were those line numbers? I apologize.
It's lines 15 through 20 are what I just read on 407.
Okay. And how did the judge rule on your motion for mistrial?
She didn't grant it. She overruled my motion. She overruled my motion, but I'm sorry. But I also, I mean, we had a conversation about what had happened.
Okay. Did you ever waive your objection in your motion for mistrial?
No.
Did you ever acquiesce in the court's ruling?
No.
Okay. Okay, moving on to paragraph 8. Do you remember the introduction into evidence of a prior interview of witness Jeremy Andrews?
Is this the same situation, different trial? So you're going to cover it, but just to streamline it, your paragraph 7 in trial 1 was Alan Smith bolstering Jeremy Andrews, and the paragraph 8, it sounds like it's a similar setting. It may be that the state tried to do the same thing in the second trial.
Yes, they did, except this time they actually used an exhibit of a prior out-of-court statement and played it for the jury. It states Exhibit 265. If you want to turn to pages 676 to 67, oh wait, actually I apologize. I think the persons whose testimony was being bolstered was at volume 3, pages 600 to 607. And then the bolstering occurs on volume 4, 676 to 678. So you can look at, if you want to flip open volume 3 and have it at page 600, and then volume 4 at page 676.
Okay.
Okay. So if you want to start with volume 4 at 676, does that refresh your recollection as to what was happening during the trial at that point? 676 to 678 regarding State's Exhibit 265.
Yes.
Okay. And did you object?
Yes.
And what was the basis for your objection at that time?
I don't recall. I would have to, I'll defer to whatever the transcript.
Do you want to
says.
just take a moment and read it
Um,
and see if maybe you had the opportunity?
hearsay, it was a hearsay objection,
Thank you.
and that it was improper impeachment, and it was evidence of a prior, I'm sorry, it was not evidence of a prior inconsistent statement, but it was just bolstering Jeremy Andrews' statement.
Thank you. At any time, what did the judge rule?
She overruled the objection.
Okay, and did you ever waive your objection based on hearsay, improper impeachment, and improper bolstering?
No, I don't believe I did.
Did you ever waive your objection that it was not a prior consistent statement?
No.
Okay. Did you ever acquiesce in the court's ruling?
I don't believe I did. Maybe.
Okay. Paragraph 9. If you want to flip to hold on, I apologize, I got lost. Okay, if you want to turn to volume 5, pages 787 to 788. And you recall making a similar objection during the testimony of State's Witness Vincent Velazquez. For the court printed that Celazquez.
Yes, I do. And it's yes, I do. It was Velasquez,
Yeah.
but that's neither here nor there.
It's a V, not a
It's
C.
a V, not a T.
Oh, so.
It's all right. We knew who you meant.
Okay, thank you. Okay, so at this point, could you please give the court context about what's going on?
It was similar. I felt like the witness was bolstering the testimony of a previous witness, Mr. Murphy, and that there was no impeachment issue. It was improper impeachment.
Okay, so as to both of these paragraphs, was it your contention that the witness who was being bolstered had not been impeached?
Correct.
And therefore it was not proper to allow a prior consistent statement to come in?
Correct.
Okay. And how did the court rule on paragraph 9 as to the bolstering by State's Witness Vincent Velazquez?
He overruled the objection.
Did you waive your objection?
No, I don't believe it did.
Did you acquiesce in the court's ruling?
No, I don't believe it did.
All right, going on to paragraph 10. And this is the same paragraph as to trial number 1 regarding the defendant's cellular telephone. Did anything happen between trial 1 and trial 2 with regard to your strategic decision from trial 1 not to seek to suppress the telephone?
No, I mean, no, nothing different would have changed. I mean, I would have talked to Mr. Allen, obviously, between the two trials, but other than that, no.
Okay, so basically all the answers you gave earlier regarding your trial strategy for this same piece of evidence from trial 1 equally apply to the second trial?
Yes.
Did
I
you,
believe.
I'm sorry to interrupt. Did you, Ms. Gubani, argue effectively the same defense or defenses in the second trial?
Yes.
It wasn't suddenly, he wasn't there or whatever you argued in the first trial, to some effect, you argued again in the second trial.
Yes, we presented the same legal defense theories.
Okay.
Your Honor, do you want me to re-ask the question or can we just incorporate them by reference?
I think we can do that because of what I just heard. You know, if it was a completely different defense theory, you might have wanted to explore it. But all of the reasoning that went into Ms. Gubani's decision not to seek to suppress the search of the cell phone or the residence, it seems applies with equal force or lack thereof in the second trial.
Yeah, I understood why you asked that question. I was thinking I should have asked that, but thank you. Okay, so basically everything as to the suppression issues regarding the cellular telephone from trial 1 apply with equal force and weight to your decision making as to trial 2.
Yes.
Okay, also, as to paragraph 11, this is also a repeat of the search of the defendant's residence. Was it the same exact trial strategy reasons for your failure to oppose the of the evidence about the search of the defendant's residence in trial 2 as trial 1?
Yes.
And I'll ask this question the judge did, which is, was your strategy for your trial 2 and trial 1 the same? And therefore you have the same strategic reasons for paragraph 11, not seeking to suppress the evidence from the search of the house.
Yes.
Okay. Paragraph 12 is basically the same thing that we went over for paragraph 13, where you were talking about how many times you met with the defendant. Did he have witnesses? Did you investigate? So what happened between trial 1 and trial 2 to possibly enhance your defense?
I mean, talk to him. I mean, for certain, we would have started by talking to him, going over with him what happened in the first trial, talking
Him
about,
being your client.
yes, I'm
Okay.
sorry. Yes, when Mr. Allen, talking to Mr. Allen, making sure he understood what happened in the first trial. And if I recall, this is me recalling from my memory, without having reviewed this, but actually in the first trial, I want to say there were some things that the lead detective, Alan Smith, testified to, that we thought were extraordinary, that we wanted to look into and follow up between the two trials. And we had made some efforts to do that, to follow up on those things. And we had to, do some canvassing, if you will, for one of the neighborhoods that came up in the first trial. And so I do recall that. I mean, those were, mainly the same things. We had Mr. Allen, we had some conversations about some of the statements that the lay witnesses had made, because they were a lot of them had some personal relationship or prior interactions with him. And so we had to follow up with him about those to find out whether or not there was anything we need to refute or any new people that maybe we wanted to talk to. And that was mostly it. I mean, we just, reviewed the first trial, talked about whether or not how we wanted to proceed in the second trial. And that was, I think that was most of what we did.
Okay, if you would once again try to look at the table of contents for the trial, possibly, and to see if you called any witnesses, or do you remember if you called any witnesses?
I don't believe we call witnesses. I don't believe we call witnesses.
Okay. And did you discuss with Mr. Allen whether there were any witnesses he wanted you to call?
We did. We.
Okay. And did he tell you that there was a witness he wanted to call that you did not?
I don't believe so. And quite candidly, I would have deferred to him, and not just Mr. Allen, like any client that I represent. I mean, my attitude is this your trial. So if there's an issue, I likely would have deferred to the client.
Okay. Did you discuss with Mr. Allen the ramifications of whether he should testify or not testify?
Yes, we did.
And did he testify?
No, I don't think he testified in either of his trials.
At any point, did he discuss with you between trial number 1 and trial number 2 that he wanted to testify?
No, Mr. Allen, no. Mr. Allen, as far as I can recall, never expressed an interest to testify in either of his trials. We did talk. We talked more about after the first trial, because certainly the statements were at issue. So we talked more about that, the statements and, testifying and not testifying, but that's it.
Did you discuss with him prior to the fact that the jury was 10-2 or 11-1 to convict?
Yes, he knew that. And we knew, yes, he knew that. And we also had a bit more information about the jurors who hung.
Who hung?
Yes.
Okay. And at any point, did he indicate to you that he wanted to take a plea?
No, we talked about pleas and maybe getting him I don't, Mr. Allen, as far as I can recall, he wasn't interested in a plea offer and the state wasn't interested in making one. Yes, this is
Okay, I believe that's all the question I have, subject to redirect.
All right, Ms. Pollock, you still with us?
I'm still with you, Your Honor. And actually, Mr. Shepard's questions and Ms. Gubani's answers were so extremely detailed. I do not have any questions for Ms. Gubani. Thank you.
All right, thank you. So you don't need any redirect, Mr. Shepard.
No, I don't.
Ms. Gubani step down?
Yes, you are released from your subpoena, and thank you for showing up today. I appreciate that.
absolutely.
Thank you so much. Where are you assigned now?
Oh, that's
In
right.
state court.
In state court?
Yes,
Okay.
Got a promotion.
A particular judge, or are you a supervisor?
I'm a supervisor for
Great.
state court.
All right, well, thank you for being here. I appreciate it.
Thank you.
I forgot to do this earlier today. Who's the court reporter today?
Ms. Rivers?
Karen?
Yes.
Thank you.
Hannah Rivers.
You know you're going to get a letter from me.
I'm already on it, Mr. Shepard.
Okay. I
Yeah, you
think,
can leave them right there. Thank you so much.
I think at this point, it would be appropriate for me to have a brief private conversation with my client.
Why don't we do that? So, Mr. Shepard, I have written down, if you don't, the ID number for the meeting and the password, because I think what will make the most sense is if you go into the jury room and call them, because I can't make all these machines not sort of talk to the whole system, if that makes sense. So if you dial in, then you can go into the jury room and I can move you and the Coffee Correctional Tile, which is your client, and we can get the two of you speaking in private.
Okay. So you're going to give me the login information?
Yes.
I think I may have got that from Deidre in an email.
It did change once. So why don't I just give it to, if you've got it where you can click it, that's great. There was a new Zoom link that Ms. Hansberry sent out late yesterday.
Okay.
Because we got some new equipment in the courtroom.
If I can just find that email, then I can just hit it. It says canceled, and I think.
So the one that says canceled would not be the one you want.
I got it.
Okay,
Let me just,
great.
so just go in there.
Well, why don't you see if you can connect right here?
Oh,
And if you can, then once you're in a private space, we'll do that. Mr. Allen, is there someone in the room with you who will be able to unmute your, oh, I see a body in there. That's great. Okay.
Oh, look at that.
All right. Mr. Shepard, you're in.
Hold on.
So why don't you go into the jury room? The feedback will stop once we get you in there.
I can also do this for a minute. There we go. Okay, just head for the jury room.
Yep. So we're off the record. Well, we're on the record for one moment. I am going to put Mr. Shepard and Mr. Allen into a private breakout room. They will stay there until Mr. Shepard comes back out here, saying he's ready to go.
Okay, should I have got something to push?
Wait right here. Let's make it happen so we know. All right, it should work now. You bet. And they're both in. Okay. So we're going to stand down for a little bit. Please stay near your screen. You don't have to be on the screen. And when Mr. Shepard returns, we'll get both Mr. Allen and Mr. Shepard back in the mix. Thank you.
Your Honor? Well, we're on. I go to the bathroom real quick.
Yeah, can I kick you out of the call?
Yes. I'm trying to.
You did it. Great. Sure. Welcome back, Mr. Allen. We're going to just, the break is going to take a little bit longer. Mr. Shepard's taking a quick break and then he'll be back in court. Okay. All right. We are back on the record. We took a break so that Mr. Shepard could speak in confidence with his client, Mr. Allen. Mr. Shepard dialed into our Zoom call from his cell phone, went into the jury room, And then I moved both Mr. Shepherd and Mr. Allen into a breakout room where they were able to speak privately. That conversation is now over. We're back, meaning Mr. Shepherd and I are here in court. Ms. Pollack and Mr. Allen are appearing virtually. And we are on to the next phase of the proceedings. Ms. Gubaini's testimony wrapped up. And my question to you, Mr. Shepherd, is do you have any other witnesses that you want to call at this time?
Yes. I went through the colloquy with my client. My client has indicated that he does want to testify, but he feels that he should be allowed to testify in the presence of the finder of fact, the judge.
Okay.
In my presence.
And his testimony, just from a summary perspective, would be primarily about what we've been calling paragraph 13 and paragraph 12 in the two trials. In other words, Ms. Gubaini's communications or lack thereof with Mr. Allen, or are there and related topics, or is there something completely different?
It is primarily going over paragraph 13, the issues and topics raised in paragraph 13, and it may touch on some of the other trial strategy decisions she made that he was not consulted on.
Okay. Ms. Pollack, do you have a perspective on whether Mr. Allen's testimony ought to occur now where you and he are appearing virtually, or if it should occur at a later date when he's here in court and you'd have the opportunity to be here in court, but could also appear virtually?
Your Honor, I don't. This is his motion for new trial. The state does not have a position on whether he should be in person or be testifying through video conference as he is today. We will defer to the court's judgment on that.
Okay. I find that given what Mr. Shepherd has forecast is the heart of his challenge through what we're calling paragraphs 13 and 12 for it's one motion for new trial, but it's two trials. In other words, the allegation that Ms. Gubaini failed to adequately consult with Mr. Allen, that it's appropriate to have Mr. Allen here. I was able to watch Ms. Gubaini testify and ask her questions without any of the choppiness that sometimes comes up when someone is appearing remotely. And Mr. Shepherd is forecasting, and I use that term intentionally. He's not guaranteeing because his client hasn't testified yet, but Mr. Shepherd is forecasting that Mr. Allen's testimony will differ markedly from Ms. Gubaini's. And that would leave it to me to decide if there are inconsistencies between the two, which testimony do I credit more? And I think it is fair to have Mr. Allen here. If he's testifying remotely, I am perceiving his testimony necessarily differently than I did Ms. Gubaini. It might help him, it might hurt him, but it's different. And I don't think we ought to inject that into this particular motion for new trial, which has, unlike many others, a scenario where trial counsel and client are disagreeing on something. And so we will have Mr. Allen brought to Fulton County when I can arrange that. I appreciate Mr. Shepherd's observation that there is some movement of Department of Corrections inmates. I was aware of that as well, mostly away from Fulton and into DOC. It is much more limited in the other direction for all sorts of reasons that I appreciate and support. But at some point, there will need to be situations where someone in DOC custody comes to a courtroom, and this is one of those scenarios. Modern technology has worked wonders in our ability to continue the business of the court on the civil and the criminal side. But there are a handful of scenarios where, especially on the criminal side, it's appropriate to require in-person interaction. And this one topic about Mr. Allen's claims of inadequate or insufficient consultations with his lawyer falls into that area. So we will table that piece. I may yet, depending on what my schedule is like, enter an order on some of the other grounds, because I don't think Mr. Allen's testimony is going to address, nor would it, if it did, substantively change any analysis I have to make on, for example, whether Judge Downs committed error when she denied the mistrial in connection with Ms. McCoy's testimony in the first trial. So there may be some discrete issues that I feel like I can tackle, and we'll at least get closure on those. But I will leave open this question of Ms. Gubani's, the extent of her consultations with Mr. Allen, and as Mr. Shepard has pointed out, the possible ripple effect that may have on Ms. Gubani's, as she described them, her strategic decisions not to seek to suppress the results of the cell phone search and the search of the residence.
Your Honor,
Sir,
I have not yet made argument as to anything.
agreed. So we're not done. What we're saying is that I'm leaving evidence open because
to argue.
You will be allowed to argue. I may say I've heard enough on certain things, but I agree with you. We haven't had any argumentation. And so we'll turn to that. I just didn't want anyone to leap up, or whatever one does on Zoom, raise a hand saying, wait a minute, evidence isn't closed. Evidence is not closed. It will be reopened for Mr. Allen to testify on whatever topics, but it sounds like, and this makes sense, I think it's a fair forecast, that it would be largely focused on his perception of the breadth and nature of the consultations he had with Ms. Gubani and her colleagues. There were two different attorneys who supported her during the trials, Ms. Korean in the first trial and Ms. Nunn in the second trial. So let's turn to argument, unless I need to make sure, Ms. Pollack, you weren't planning on presenting any evidence.
I was not, Your Honor.
Okay, and you'll certainly have a chance to cross-examine Mr. Allen should he decide it makes sense for him to testify. He'll need to answer all of your questions as well, not just Mr. Shepard's. So let's turn to argument. Mr. Shepard, your motion, so you can get us started on what it is you want to cover. And no, you don't need to argue the ineffective assistance grounds yet, because the evidence isn't closed on that.
All right, Your Honor, the general evidentiary grounds is going to be the same case law and basically the same argument for both trials, just the evidence will be for trial 1 and then trial 2. So paragraph 1 of both of my one for jury trial in November of 2017 and one for the jury trial in February of 2018 is that there was insufficient evidence presented at the trial to warrant the jury verdict, and that this should result in the court acquitting and discharging the defendant of the charges against him. So this is not asking for a new trial. This is asking for an acquittal and a discharge as to paragraph 1 of both sections of my amended motion. The primary case is going to be Jackson versus Virginia, 443 U.S. 307 in 1979. And there's a list of cases in my motion that I'm going to just incorporate by reference into my argument without having to read all those names and numbers. Oh, I'm spotlighted. Okay, so based on those cases, if you look at the evidence, the jury verdict was not warranted and that there should be an equivalent discharge of Mr. Allen as to all charges. Paragraphs 2, 3, 4, and 5 are a little different. Paragraphs 2, 3, 4, and 5 are asking the court to adopt its constitutionally required role as the 13th juror. These paragraphs allege that there was an insufficiency of the evidence and the evidence is against the weight, or the jury verdict is against the weight of the evidence, that the jury verdict is contrary to the law. That's paragraph 2. Paragraph 3, the jury verdict is contrary to the law and evidence is paragraph 3. the evidence was, okay, and paragraph 4 is if the evidence was sufficient, it was sufficiently close to warrant the court to exercise its discretion to grant defendant a retrial. And paragraph 5 is that the jury verdict is contrary to the principles of justice, fairness, and or equity. So the court should, as the 13th juror, grant a new trial. Those come from 2 statutes. The first statute, if I can find, the statute has disappeared. Well, it's OCGA. God, I can't remember the statute now. That is weird.
I'm familiar with them. I can't give it to you either, but I'm familiar with it. And it is part of the work I need to do in every motion for a new trial.
It's OCGA 5-5-20 and OCGA 5-5-21. And one of the primary cases is going to be White versus State 293 GA 523. That's a 2013 case. Allen versus State 296 GA 738. That's a 2015 case. And there's some additional cases cited in my motion that I would ask the court to reference. But once again, all of those are asking the court in its capacity as to both trial 1 and trial 2 to exercise its discretion as the 13th juror to grant to Mr. Allen a new trial. As to paragraph 6, you heard the testimony of Ms. Gubani as to, this is trial number 1, paragraph 6, as to the testimony of Ms. Herlisha McCoy, placing the defendant's character at issue by basically commenting that he was bragging about how he has bodies on him, that he's a murderer. We believe that the court improperly denied Ms. Gubani's timely motion for new trial based upon this improper character evidence. The court is well aware of the case law in this area, but we would just cite to Taylor, Taylor versus State 303 GA 225. That's a 2018 case. And basically that it's not appropriate for witnesses to bring in extrinsic, extraneous evidence that has nothing to do with the issue to be tried. It was irrelevant. It was character attack. And once the jury hears that, you can't unring the bell. So the only remedy at that point is a mistrial. This is paragraph, or this ground is going to come up a number of times throughout my presentation as to paragraph 7.
7. Okay.
Yeah, we're moving on to paragraph 7. This is the
bolstering.
Correct.
Of Jeremy Andrews.
Yes.
So Alan Smith was the detective. Jeremy Andrews was some witness.
Correct.
Okay.
So as Ms. Gubani outlined, this is paragraph 7 of this, and it's also going to resurface in trial number 2, that a witness testifies about something. And then if that witness is not impeached, it's improper for the state to then come back and have another witness testify about that same thing, saying that, oh, witness Jeremy Andrews told me the following, which is hearsay. So there's no doubt that the testimony that Ms. Gubani was objecting to in paragraph 7 on the part of state's witness Alan Smith was hearsay. The question is it admissible? And it's the duty of the state to prove that it is admissible through an exception to the hearsay. And the only exception that this type of evidence can come in through is prior consistent statement, because it was consistent. It was not impeachment. It was bolstering. And in this case, there was no impeachment of Mr. Andrews by defense counsel. So therefore, there's no reason for why this testimony should have come in. As with the improper character evidence from paragraph 6, this improper testimony was highly prejudicial and bolstered the testimony, and therefore, as to paragraph 6, the mistrial should have been granted, and the failure to grant it was highly prejudicial. And the failure to grant defense objection and the court allowing this improper hearsay testimony to come in was prejudicial to defendant. That will come up again. Paragraph 8, Ms. Gubani moved for a directed verdict. The court failed to grant the directed verdict, which should have been granted under OCGA 17-9-1. And I apologize, I normally don't jump around like this, but the main case for paragraph 7 is, so paragraph 8, let me just finish it. The directed verdict should have been granted under OCGA 17-9-1. Jumping back to paragraph 7, and I apologize. The case law that we cite to is Cowart versus State, COWART. That's 294GA333. And that's a 2013 case that basically says you can't just introduce evidence, hearsay evidence, where the purpose is to bolster. And that if it's not coming in as a prior inconsistent statement or a prior consistent statement, then it's not admissible. So we cite to the Cowart case as grounds for why Mr. Allen should get a new trial as to paragraph 7. As paragraph number 9, there was a juror who sat on the jury whose boyfriend was doing deals with the victim. And when this was learned, the defense moved to have that juror replaced with an alternate juror. The court refused to do so. And that was highly prejudicial to defendant. It ended up, the jury did convict of some counts. So we would cite to Jackson versus State, 336 GA 70, and that's a 2016 case. Okay. All right. I'm going to reserve on the ineffective assistance of counsel claims, if that's okay with the court.
I think so. I think you could address a few of them, but I also appreciate how there will be spillover depending on what Mr. Allen has to say. So let's table I won't be ruling on any of the ineffective assistance claims before Mr. Allen gets to come here to testify.
Yeah, it's because even with paragraph 10, I want to know what he has to say about his conversations with trial counsel about why they left juror number 3 on the jury.
Okay.
And other things. In light of the reservation on issues in paragraphs 10 through 13, I would also like to reserve on paragraph 14, the cumulative prejudice.
Right.
Okay. Okay, so moving to trial number 2. Once again, I reiterate and incorporate by references all my case law and code section citations for paragraph 1, which is asking the court to acquit and discharge defendant of those counts for which he was found guilty at the first trial. Once again, that main case is Jackson versus Virginia, 443 U.S. 307, 1979. Paragraphs 2, 3, 4, 5 are asking the court as the 13th juror to grant to defendant a new trial in paragraph 2 because the jury verdict is not supported by the evidence. In paragraph 3, the jury verdict is contrary to the law and evidence. Paragraph 4, in the event the court finds that there was sufficient evidence, it was close enough to warrant the trial to grant a new trial. And paragraph 5, the jury verdict is contrary to the principles and law. And once again, we would just cite mainly to OCGA 5-5-20, OCGA 5-5-21. Also, White versus State 293 GA 523. That's a 2013 case. And then also the Allen versus State case 296 GA 738. Moving on to paragraph 6. I think the court just really needs to read these comments that were made by 2, 5, and 7.
I began reading them. I had the transcript on the screen. And so someone had someone killed in Phoenix, supposedly by a gang member. So you have very helpfully, I encourage you to keep doing this. There's some pleading practices of yours I discourage, but you have all the transcript sites. And so that allowed me, while you were talking with Ms. Gubani, or she was looking, to look at the transcripts on the screen. And so I do, of course I will, but that's the only way to get the context. What did these jurors say and in what context? And then certainly I'll read the discussion that Ms. Gubani had with Judge Downs and whatever Ms. Donikowski said in response.
Yes, they're pretty over the top, and I've probably done 80 trials. I just finished my 19th murder trial, and these are some of the most egregious comments I've ever heard. I did have one trial with Judge Schwall where a juror started doing that and got stopped by Judge Schwall, and then no other juror pulled it again. So the case law we cite to is Sherman, SHERMAN versus State. That's 295 GA 338. That's a 2014 case. Roberts, Roberts versus State 259 GA 441. That's a 1989 case. And Moore versus State, Moore 156 GA APP 92. That's a 1980 case. And they all basically say that you can't allow a juror to taint the pool by spewing forth things that, his opinions and his beliefs. And then once that happens, the defendant is entitled to a new panel because that other panel has been tainted. We think Ms. Gubani's motion for a new panel was appropriate and proper, and the judge improperly refused to do so, thereby causing prejudice to Mr. Allen. Okay, in paragraph 7, once you reach the level of being a trial attorney where you're doing murder trials, you probably shouldn't be accusing defense counsel in the presence of the jury of making things up. Especially in this situation where there's a lengthy record of Ms. Gubani doing everything she can to get the transcripts from the first trial so she can have firm footing for her impeachment, and the judge refusing to do so. This is just a character attack on defense counsel. There's no valid reason for the question. It has no relevance. It has no basis for accomplishing anything other than attacking defendant's trial counsel's character in front of the jury. You shouldn't even do this when there's not a jury. But doing it in front of the jury is highly prejudicial and should not be allowed. Ms. Gubani was perfectly appropriate to ask for a mistrial. We cite to Jordan, Jordan versus State 305 GA12. That's a 2019 case. Brockman versus State, Brockman 292 GA 707. That's a 2013 case. And Arrington, Arrington versus State 286 GA 335. That's a 2009 case. And this is just wholly inappropriate to accuse another attorney of making stuff up. It's just improper. And Mr. Allen should get a new trial since it was highly prejudicial. Paragraph 8 is once again back to an improper bolstering. And this time it is again state's witness Jeremy Andrews, who is being bolstered by state's witness Alan Smith. And this time the state goes as far as to actually introduce into evidence State's Exhibit 265, which is the recording of the bolstering statements. Once again, the witness was not impeached, and therefore there is no valid exception. It is in fact hearsay. It does not fall within any valid hearsay exceptions. The case again is Cowart versus State, COWART 294 GA 333 2013. And that same case also applies to paragraph 9, where in this instance, it is state's witness Vincent Velasquez improperly bolstering out-of-court hearsay with out-of-court hearsay statements, the testimony of state's witness Douglas Murphy. And once again, we cite to the same hearsay statutes in the same Cowart versus State case. So once again, both of those paragraphs were highly prejudicial to defendant, and the court should grant a new trial to Mr. Allen based on paragraphs 8 and 9. I will once again reserve as to paragraphs 10, 11, and 12, which are my ineffective assistance of counsel claims, and also reserve argument on paragraph 13, my cumulative prejudice claim. Thank you.
You're welcome. Thank you. That was very thorough and organized, and that's valuable here with two related trials. Ms. Pollack, before you share anything you want to, if you do want to, I have another one of the Kevin Armstrong opus magnuses. He filed a 36-page response to one version of Mr. Shepard's amended motion for new trial. What I have not done, and you can let me know if you have, because if you have, I'd like to know the answer, is lined up Mr. Armstrong's response to the latest version of Mr. Shepard's amended motion, which was filed in March of this year. So they're a year apart. Something has changed. And I ask this only because I'm curious to know what the state did not have an opportunity to respond to in writing. because I want to give you that opportunity if there's something you want to respond to in writing. But it may be that what Mr. Shepard amended from March of 2020, the time of Mr. Armstrong's response, to March of this year, the fourth amended, is sufficiently minor. I don't mean that in terms of its substantive value, but it's just not that much of a change that you're comfortable just sharing with me orally your thoughts on that.
Your Honor, the state actually has filed a written response to Mr. Allen's second, third, and fourth amended motions for new trial, and that response was filed on April 20th of this year.
Oh.
So we actually have responded in writing, and
Look at that! I missed it. My bad. I found the one from March of 2020, but here on April 20th, I'm guessing we had some conversation about that, which is why you did it. So I will print that out and incorporate it in my reading list, along with what looks like about 4,000 pages of transcript.
They are lengthy. I would
All I
say
see is me.
that the state does rely on our written responses, and thankfully, Mr. Shepard is very good in his amended motions for new trial as far as with the numbering. So both in Mr. Armstrong's original response to the amended motion for new trial that was filed on March 30th of 2020, and in the state's response to the second, third, and fourth amended motions for new trial, that state's response was filed on April 20th of this year, we have indicated in our responses exactly which grounds we are responding to based on the number that Mr. Shepard has done.
Okay, thank you. And I'm looking at it now, and you did indeed, April 20th of this year. I just didn't catch it as I was wading through the docket.
There's a lot, Your Honor. So unless the court should want the state to address anything verbally, we will rely on our written responses.
Okay. Noah, you've heard what Mr. Shepard had to say, which I think was an accurate summary of what he put in his written response. And he's relying on that, and you are doing the same. I think that's perfectly appropriate. So what remains then, as I understand it, is that we've got to figure out when we can get Mr. Allen here. For that date, fortunately, all we need is Mr. Shepard and you, Ms. Pollack. We don't need to line up other witnesses, so it should be fairly easy to schedule once we clear that up with the Department of Corrections. And then we would be able to complete the evidentiary record, give you both a chance to argue what you want to argue, if anything, following Mr. Allen's testimony. And then we can be off and running with the remainder of the motion for new trial. So again, I may, if schedule allows, address the non-ineffective assistance of counsel claims other than cumulative error in an order. But it may be that we can get Mr. Allen here soon enough that it's just going to be one big order that addresses everything. Mr. Shepard, anything else that you'd like to cover today in connection with the motion for new trial?
No, Your Honor.
Ms. Pollack, anything else?
Nothing else from the state. Thank you.
Mr. Allen, do you have any questions for me about what we did today or what's coming up next?
No, sir.
All right, we'll figure out how and when we can get you transported here and get the rest of this hearing taken care of. Thank you, Ms. Rivers, for taking all this down, and we will be in touch with the lawyers as soon as we figure something out. Appreciate it.
Okay, thank you, Judge.
All right, bye-bye.